Hello everyone, I'm Yazan Ibrahim, or as some of you might know me, Yazan Abu Ghosh. Today, we're going to dive into a fascinating and essential topic, Fraud Examiner Section 2 Low Civil Actions. Today's deep dive into the world of civil actions. Whether you're an aspiring fraud investigator, a business owner, or simply curious about how organizations manage their finances, or if you are auditor, this journey will shed light on the often complex systems that drive decision making. Imagine standing in a bustling courtroom. On one side, the plaintiff, the person or entity that initiated the case, calmly reads their complaint. On the other, the defendant, the one being sued, prepares their defense. You might wonder why they're here. Civil actions don't involve crimes like theft or violence. Instead, they're about private disputes, disagreements over contracts, unmet legal obligations, or even fraudulent acts. The goal? To resolve these disputes through legal remedies without criminal penalties, offering justice to those harmed. Civil actions, simply put, are the court's way of putting things right when someone feels wronged. But how does it all work? Let's dive deeper. Civil litigation begins with the procedure in civil cases, a meticulous dance of steps that the law requires every party to follow. Imagine filing an official document, like a formal declaration of your side of the story, which sparks the official start of a civil case. That's the plaintiff filing their pleading. This legal document outlines the accusations, the facts that back them up, and the solution the plaintiff seeks, be it monetary damages or something else entirely. However, if the defendant fails to respond, imagine leaving the judge's urgent calls unanswered. They risk a default judgment where the plaintiff automatically wins. Now, fast forward to the discovery phase. Picture two detectives poring over files. This stage is where both parties exchange evidence in a pretrial investigation. Here's where it gets interesting. The tools for gathering evidence vary depending on the legal system. In common law systems, where litigation often feels more adversarial, both sides independently scramble to uncover evidence by obtaining documents, questioning witnesses under oath, depositions, or sending written questionnaires, interrogatories. Privileges, such as attorney-client confidentiality, serve as protective shields during this process. Meanwhile, in civil law systems, think inquisitorial settings, judges take on the role of evidence-seeking investigators, valuing documentary and expert insights over oral testimony. These contrasting styles bring unique flavors to how justice is pursued. Both approaches strive toward the same goal: to gather the pieces of a puzzle that will ultimately reveal the truth when the case goes to trial. Speaking of trials, can you hear the tense silence before the judge or jury delivers their decision? In common law traditions, trials unfold in two main stages: pre-trial preparations and the main event. During trial, evidence is introduced, questions are fired at witnesses, and experts clarify mind-boggling technical aspects. The verdict hinges on the preponderance of the evidence, a standard of proof that requires the plaintiff to tip the scales of justice, no matter how slightly, in their favor. Civil law trials, in comparison, rely heavily on inner conviction, the judge's confidence in the truth. Unlike the courtroom drama of the common law system, civil law trials flow through seamless sessions where the judge evaluates a combination of written records, testimonies, and their own appointed experts. Once the dust settles, the verdict decides more than just who wins or loses. If the defendant is found liable for their actions, the court grants remedies to the plaintiff. Let's expand on what these remedies entail. Imagine someone strikes your car, leaving you with steep repair bills. In the world of civil law, a monetary remedy, often called damages, amounts to compensation for your loss. Judges or juries determine the precise figure based on incurred expenses, potential future losses, or, in rare cases, impose punitive damages as punishment for particularly atrocious conduct. But what if money isn't enough? Let's say you want the court to clarify who legally owns a piece of disputed farmland. That's where declaratory remedies shine, delivering precise answers about rights and relationships, unlike monetary settlements. Alternatively, equitable remedies, like injunctions, compel someone to act or stop them from doing so, when financial payouts fall short of justice. Now, not all civil disputes end in trial. Picture a mediator calmly coaxing heated parties into resolution, or an arbitrator delivering a verdict in a confidential setting. These scenarios fall under alternative dispute resolution, ADR, where drama gives way to more collaborative problem solving. ADR methods like mediation and arbitration save time, preserve relationships, and reduce costs, making them an increasingly popular choice in fraud-related cases. Let's break these methods down further. Mediation is like having a referee, not to enforce rules, but to guide both sides to agreement. The mediator doesn't decide who's right or wrong, but facilitates compromise, ensuring that any pact reached is enforceable like a binding contract. Arbitration, on the other hand, mirrors a mini courtroom. The arbitrator acts as judge and jury, issuing decisions that may be binding or non-binding based on prior agreements. Fun fact, many contracts already require arbitration, ensuring business disputes are resolved outside of court. Before we close, a fascinating detail worth mentioning is the role of fidelity insurance in fraud cases. Imagine running a business only to discover an employee committed fraud or embezzlement. Fidelity insurance steps in to cover such dishonest acts, protecting companies from devastating losses. Whether it's theft, forgery, or fraudulent fund transfers, this insurance ensures that businesses aren't left high and dry. However, it's worth noting that policy limitations, exclusions, and deductibles can impact coverage, making it critical to adhere to compliance rules when submitting claims. The insurer, once they pay up, assumes the right to sue the offender through subrogation, emphasizing that justice doesn't end at mere financial recovery. This journey through civil actions, remedies, and alternatives highlights the complexity of how disputes are resolved. From courts to ADR and even insurance protecting against wrongdoing, the justice system presents a myriad of paths to resolution, ensuring there's always a way forward. The beauty of civil actions lies in their adaptability, shaping solutions to fit the unique circumstances of every conflict. Whether you're in a courtroom, in mediation, or simply seeking insurance support, the ultimate aim remains the same: fairness and resolution. Thank you for watching, and as always, continue learning. Stay curious, and we'll see you next video.